From the daily call list, under the heading for orders we prepare, item number 1, LPA number 599 of 2019, Mr. Gaurav Abhishek for the appellate, Mr. Rajiv Sinha for the respondent.
Yes. Anyone appearing for the appellant?
In this case, I appear on the respondent number 4, Binav Bhavin.
Yes. 2 weeks' time is allowed to learn counsel for the appellant to remove the following surviving defects. Mr. Mithilesh Singh for the university.
Minor, obliged.
Next.
लॉर्डशिप पीए को पीए साहब को बुलाएं एंड लॉर्डशिप टेस्ट क्लास दे
नहीं, यहाँ लिख रहे हैं तो रंजीत है, यहाँ लिख रहे हैं
लॉर्डशिप आइटम नंबर 2 WPT number 495 of 2022 Mr. Kumar Vaibhav for the petitioner, Mr. Rahul Amar for the respondent.
Milords, I may be permitted to withdraw this writ petition, Milords. The assessment order has already been passed. Milords, only liberty may be given to me, Milords, to challenge the assessment order as well as the initiation of reassessment proceedings in accordance with law.
Initiation, you will challenge in appeal.
Milords, I will raise that point in appeal before the CIT that the initiation itself was wrong.
Very well. The writ petition was preferred for the following reliefs. Para 1, A, B, C, D. Stop. However, there is a surviving defect also to be removed.
Milords, that defect I was praying may be ignored, Milords. It's a minor defect of the address of the National Faces Assessment Center.
Surviving defect relating to address of respondent number 1 and 3 is ignored. Stop. However, learned counsel for the petitioner, Mr. Kumar Vaibhav, submits that during pendency of the writ petition, the assessment order has been passed by respondent number 5.
Milords, it is respondent number, Milords 3. Respondent number 3, Milords.
3. In the reassessment proceedings under section 142(3).
Milords, it is 147 read with 144. It is 147 read with 144.
142(3).
नहीं 142(3) है या
142(3) होगा सर.
हाँ वही तो
147 read with 142 subsection 3.
147 read with 142(3) of the IT Act. He therefore seeks permission to withdraw the writ application, however, with the liberty to assail the assessment order and the initiation of proceedings under section 147 of the IT Act before, in accordance with law, before the appropriate authority. Stop. Then counsel for the respondent, Income Tax Department, Mr. Rahul Lamba is present. He does not object to the prayer. In view of the prayer made on behalf of the writ petitioner, the instant writ petition is dismissed as withdrawn. It is open for the petitioner to pursue his legal remedies as is permissible in law.
Much obliged, Milords.
Item number 3, WPT number 798 of 2022, Mr. Nitin Kumar Prasad for the Mr. Nitin Kumar, Mr. B.S. Patik.
Milords, in terms of my lord's last order dated 14th March, Milords, we have removed the defect on 1st of April 2022, Milords.
And counter also has been filed.
No counter affidavit has not come, but I have filed my supplementary affidavit, and that is important, Milords. Because the interim order which was passed by SESTAT, I have brought on record the said order and the deposit receipt. Minutes at page 5 of my supplementary affidavit is the order passed by the SESTAT. If my lords may have a look at page 5 of my supplementary affidavit.
Mr. Pati, are you appearing?
Yes.
And my lords, page 7 is the deposit receipt.
Mr. Pati, are you appearing?
Minutes, I don't think he's on board. His name is not reflecting, minutes.
Learned counsel for the petitioner, Mr. Nitin Kumar Pisari, submits that the surviving defects have been removed on 1st of April 2022. Office to verify. Counter affidavit has not been filed. In terms of the order dated 14th March 2022, though petitioner has filed a supplementary affidavit enclosing the
Minutes at page 5, interim order dated 1st of July 2015.
interim order dated 1st of July 2000
15, my lords.
passed by the learned SESTAT at Kolkata,
And the deposit receipt at page 7, my lords.
and a copy of the deposit receipt dated
This is dated 4th September 2015.
2015 by way of a supplementary affidavit.
Yes, my lords.
However, awaiting counter affidavit on behalf of the respondent, let the matter be listed on 18th April or 19th April. Rejoinder, if any, may also be filed within this time.
Yes.
You tell Mr. Pati.
Minutes, I'll inform him. Only one thing, minutes. Status quo as on date may be mentioned. Minutes.
No, status quo.
Because of the fact, minutes, if my lords would see page 8 of my supplementary, minutes, they have issued a notice that if you do not get any order, we will attach the accounts. Minutes. They'll take recovery actions.
So, in that case, let Mr. Pati be also present. We thought that we'll keep it on a 19th, pleadings would be complete.
Minutes, otherwise, I would not have pursued. Only because of page 8, minutes, I am trying to pursue, my lords.
Anyway, then pass over for one or two cases. You ask Mr. Pati to go ahead.
Minutes, I'll just ask him.
Yes.
Item number 4. WPT number 1125 of 2022. Mr. Anish Kumar Mishra for the petition.
In this case, I am appearing for the petitioner. Lord. I am praying for 1 week time to remove the defection.
So item 4 is similar to item 25.
Yes, Lord. See, the financial year that is changed, Lord, that is 2017-18 involved in this case. Lord.
So what we can do is to club both the cases together and list it after 1 week so that we can hear both the matters together.
Let's 25 वाला आज सुन लिया जाता है मुझे इसको हम 1 week में डिफेक्ट क्योर कर देते हैं.
If there are similar matters, then let it be listed together. Next Wednesday also we can keep you remove the defects within this time.
उसके साथ 2 केस और टैग किया था जो ने लास्ट ऑर्डर में बट वो आया
टैग नहीं किया है वो तो ये place along with the record का ऑर्डर किया है.
Yes, sir.
इसलिए their records must have come, but since we are
Yes, record is there, but those cases are admitted case.
Yes. इसको रख दिया जाए नेक्स्ट वेडनेसडे पे उसको सुन लिया जाता है और क्लाइंट का इंस्ट्रक्शन.
We will hear it on next Wednesday.
Yes.
Who is for the respondent? P2.
Name of PS Pati is appearing also.
Really, in the item 25.
25 में
Sachin Kumar.
Mr. Sachin Kumar.
Item 25, you will be arguing or some other counsel from outstation will?
Some other counsel from Mumbai, Your Lordship, he will be assisting Your Lordships.
Very well. So you remove the defect in item 4 and we will club it, and next Wednesday we will take it up.
Yes, Your Lordship.
Item 4 में लिखिए, then counsel for the petitioner, Mr. Anish Kumar Mishra, undertakes to remove the following surviving defects by Friday or Saturday? Saturday?
By Saturday.
By 7th, 8th, 9th of April 2022, office to place the file. If defects are removed, let the matter be listed along with WPT number 5531 of 2021, also on board today on, what is the date? Next Wednesday?
That is 13 to
13th April 2022, under appropriate heading.
Lordship, 9th Saturday है, 9th Saturday को second Saturday.
अच्छा, second Saturday है, तो फिर Monday को कर, by Monday.
by Monday. Your Lordship.
Very good.
For orders, item number 5, first appeal number 250 of 2019, Mr. Ashutosh Anand, Mr. Nijit Sinha, for the appellant, Mr. Swati Salini for the.
Third, I am appearing on behalf of the applicant. Lordship. In the last occasion, they were directed to seek instruction, Lordship.
My lords, I'm appearing for the respondents. So the remaining amount of rupees 5,80,000, if the petitioner is willing to pay by 30th of April, we have no issue.
So that was, we had proposed to pay it by 31st of March. That has crossed.
Yes, my lords.
Mr. Kedar, your client is in a position to pay by 30th of April.
They have also filed IF to that effect.
Lordship.
Appellant's counsel, your client is ready to pay by the remaining amount by 30th April.
Lordship.
So we'll record your undertaking and the concession of the respondent's counsel that he is satisfied if the remaining payments are made by 30th April 2022.
Your Lordship, because it is coming after long time, Your Lordship. So I'm just praying that short passover may be granted so that I can seek fresh instruction from the client, Your Lordship. For one
IA
case,
was
Your Lordship.
IA was filed.
Lordship.
You filed an IA to seek an extension up to 31st March.
Lordship.
So, to 30th April, sorry.
30th April.
30th of April 2022, Lordship.
Yes.
So then, as per your undertaking, you pay.
Lordship.
Okay. Mr. Your good name, Land Council?
Akhorya Vinash, my Lordship.
No, other side.
My lords, Kanishk Dev. However, name of Ms. Swati Shalini may be reflected.
Ganesh Dev, along with Mrs. Swati Salini, appearing, Land Councils appearing for the respondent. Submit on instructions that the respondent is agreeable to payment of the balance amount of rupees 5,80,000 by 30th of April 2022 as prayed for by the appellant to IA number 7411 of 2021. Stop. When counsel for the appellant submits that the appellant has abide by his undertaking to pay the balance amount by 30th April 2022 as indicated in his in the interlocutory application. Accordingly, the terms of the settlement agreed between the parties for payment of the permanent alimony of rupees 10,80,000, no, 12 lakhs is modified to the extent that the balance amount of rupees 5.80 lakh shall be paid by the appellant by 30th of April 2022. Stop. Let the matter be listed accordingly. My IA number so and so stands disposed of. Let the matter be listed on 9th May 2022 for us to report compliance and for passing appropriate order on the appeal.
Item number 6, first appeal number 296 of 2019, Pradeep Kumar Devmani for the appellant, Mr. Amit Kumar Sinha for the respondent.
May it please your lordships. My lords, the appellant has filed one IA number 2601 of 2022. Lord, seeking permission of this honorable court to withdraw this appeal in view of the fact, my lords, that the appellant was earlier aggrieved by that part of the impugned judgment and decree by which he was directed to make payment of rupees 5 lakh to the respondent wife by way of permanent alimony. Now he is ready and willing to pay that amount of rupees 5 lakh, my lord. And in paragraph number
Right.
7 of my IA, my lords, I have stated that by the end of April 2022, my lords, the appellant will pay the amount of rupees 2,50,000, and by the end of July 2022, he will pay the remaining 2,50,000, my lords. So, in view of such undertaking, the I may.
Appellant husband was aggrieved by the judgment and decree dated 17 July 2019, passed, and decree dated 1st August 2019, passed by learned so and so in so and so, whereby the appellant was directed to pay a sum of rupees 5 lakhs as permanent alimony to the respondent within a stipulated period. Stop. During pendency of this appeal, the parties have, during pendency of this appeal, adjournments were sought by the, on the last date, adjournment was sought by the appellant as endeavors for out-of-court settlement were going on. Stop. Interlocutory application number, thereafter, interlocutory application number 2601 of 2022 has been preferred by the appellant, seeking permission to withdraw this appeal with categorical statement made at paragraph 7 as under. Stop. Learned counsel for the appellant, Mr. Pradeep Kumar Devmani, therefore seeks permission to withdraw this application, this appeal. Stop. Para. Since the appellant is no longer aggrieved by the offending part of the impugned judgment and decree and is agreeable to pay the permanent alimony in 2 installments as indicated here and above, there is no purpose in keeping the appeal pending for adjudication. Stop. Accordingly, the appeal is disposed of. Dismissed as withdrawn. What do you want?
Dismissed as withdrawn.
Dismissed as withdrawn. IA stands disposed. Pending IA stand. Wo IA disposed of. Rest of the IAs are closed.
Much obliged.
Yes.
Item 7, LPA number 587 of 2019, Mr. Piyush Patidar for the appellant, Mr. Pratyush
Yes, my lord, this is an appearing for the appellant.
Lordship, I am appearing on the behalf of the respondent, Lordship. I pray for adjournment on the ground of Mr. Pratyush Kumar due to the rituals of last rites of his grandmother. That's why I pray for adjournment, Lordship.
How much adjournment?
Lordship, 1 week, Lordship.
My lord, may I pray, my lord? May I pray?
Limitation
My lord,
petition can be,
also from outside is appearing this matter, my lord. Therefore, this case may be fixed on any day after 18th, my lord, for physical hearing, my lord.
As prayed for by learned counsel for the parties, place the case on 21st April
Yes, my lord.
2020.
There is an IA application, my lord.
So that we will decide on that.
Right. Right.
Respondent's counsel is not ready.
Item 8, first appeal number 50 of 2021, Mr. Dilip Kumar Chakraborty for the appellant.
I am appearing on behalf of the petitioner, my lord. On last occasion, it was directed to issue notice, my lordship, and after that, on 23rd 11/2021, I have filed notices before the court.
Service of notice has been refused as per the office note and the endorsement made on the undelivered registered cover with heading by the sole respondent. Stop. Same is the endorsement on the undelivered speed post. Stop. As such, notice is treated as valid. Call for the lower court reports in connection with so and so from the court of so and so. Place the matter under the heading for hearing on receipt of the LCR.
Oblige, my lord.
Yes.
May I just, I had called Mr. Pati for some emergency. He had to go out from his residence, so he is not joined. Mrs. Ranjana Mukherjee is online, my lord.
We have, Mrs. Mukherjee, are you prepared in this matter? If this
We just got instructions yesterday only, so I would pray for a week's time to bring it on record. We have just received it yesterday evenings, Your Lordship. So we could not file a supplementary to that. So if this matter can be taken up next week, by that meantime we'll be bringing it on record by way of a supplementary. We have got instructions. It's my humble request on behalf of Mr. Pati that he wants it to be taken up next week. Or tomorrow, because
in that event, can I only pray, Milord, since Milord had already fixed it for 18th, so let it come on 18th itself, Milord.
Very well, 18th, same order.
Same order, Milord. But only one thing, Milord, since Milord, I have brought on record the interim order and the deposit receipt. Milord, if the status quo as on date can be, Milord, that is all I was praying, Milord.
Actually, because in effect, I have not gone through
no, I understand, Milord. I would not pursue it. I would not pursue it. Let it come on 18th, Milord.
18th.
Much obliged.
19th.
19th.
19th April.
Much obliged.
For admission item 9, WPT number 619 of 2019, Mr. Pandey Neeraj Rai for the petitioner, Mr. Rajiv Sinha, Pawar Kumar Sinha.
May I please, Your Lordship, my lord?
Yes.
My lord, this is a matter, my lord, where under the Central Excise Act 1944, that is the pre-GST period, my lord, and manufacturer had two options to make payment of duty. One was that to cash deposit, which was usually being paid by a personal ledger account that was called PLA, and the other method of payment was by input credit. When the CGST Act came in and the Central Excise Act was repealed, there was a transitional provision made that all such credit and deposits which were there under the Central Excise Act may be transferred to the CGST and utilized under the CGST Act.
Only Senvat credit. Only
Sanvet, it was Sanvet credit. I had my lord under the personal ledger account 1 crore rupees of a balance that I have kept it for the payment of central excise duties, and that excise duty when I keep the money in the PLA account, it goes out of my hand and it goes in the government's account, which is adjusted against the liability of central excise.
The point is that the legislature has specifically use the expression SENVAT credit in section
Yeah,
40.
my lord, yes, that's
And you had an option to seek refund. In fact, under the transitional provision also, within a time frame, there was an option to seek refund of course, any such credit or tax or invoice, cess section. In fact, yes, you please carry on.
Yes, my lord. The Section 11B of the Central Excise Act, which was the only provision for the purpose of refund, was not applicable in this case because that this payment in PLA was not a duty. It was an advance deposit made by me. And if my lord, we kindly see Section 11B, it is in relation to Central Excise Act. It is in relation to duty, my lord. Section 11B, my lord, may I just place it, my lord?
Yes.
My lord, claim 11B is, my lord, claim for refund of duty and interest if any paid on such duty. Any person claiming refund of any duty of excise and interest. Since, my lord, the amount in PLA credit is not a duty, it is a deposit made by me. Section 11B was not attracted, and Honorable Supreme Court in the ITC case judgment has delivered that 11B can be made operative only when there is an appellate order for refund under an appellate proceeding, otherwise refund is not possible. So, my lord, no provision was made for the purpose of refund under the CGST Act or under the Central Excise Act. There was no such provision. Now, thing is that this money which I had in my PLA account, this I was entitled to carry forward. There should be some mechanism for carry forward.
So we cannot step into the shoes of the legislature.
My lord, it is the interpretation of this that my money is not forfeited. In the affidavit in opposition, they are saying that I have been entitled to, I can take a refund, but there is no provision for refund. So, my lord, my submission is this, that it is to be read in a manner, section 140 is to be read in a manner which will include with all my credit which I have, including the credit in my PL account. That credit cannot be, is not being forfeited because there is no exclusion. And when there is no exclusion of that, it is forfeited. There is no provision for it. Some provision has to be made. So, my lord, earlier, my lord, in such a situation, government has issued a circular in 1993, my lord, way back. There, they in in 2018, my lord, sorry, in 1993, when special excise duty was repealed, was abolished, and those who have paid the duty under the special excise duty, or who had the money in the PLA account for payment of special excise duty, could utilize their PLA credit in the general account. But this circular I have annexed at page 40 of my petition. But though it is under the old act, but a mechanism was made for the purpose of utilization of it in the paragraph 3 of that, my lord, we kindly see paragraph 2. Paragraph 2, if I read that circular, issue was examined in consultation with the chief controller of account, and
You
it has been
see, Mr. Counsel.
Yes, my lord.
You are appearing from some outstation.
Yes, my lord, yes.
There are other provisions under the chapter transitional provisions, which perhaps miscellaneous transitional provisions section 142 is one of them.
My lord. What I'm submitting is this: if I am entitled to transition of credit, whether which I have done under trans one, I have done under trans one. If it was
no, you are perhaps missing the point. First of all, under section 140, only Senvat credit can be carried forward. So there, on a literal interpretation of the tax provision, your chapter is closed. Now, under 142 miscellaneous transitional provision, there is a subsection 3.
Yes, my lord.
Every claim for refund, if you have got it.
Yes, my lord. Every claim for refund filed by any person before, on or after the appointed date for refund of any amount of Sanvet credit, duty, tax or interest or any other amount paid under existing law shall be disposed of in accordance with the provisions of existing law. My lord, so I am pushed to the Central Excise Act.
So therefore, we cannot expand the scope or the literal expression of the GST Act. If at all, PLA amount cannot be transited to the input tax credit and GST. That is very clear from section 140. If the legislature had thought of incorporating such a provision, it could have incorporated it by way of an amendment also. Now, in case it is not liable to be transmitted or carried forward, then you could have claimed a refund under the existing law. Section 142(3) is one such provision which takes care of that kind of an eventuality.
I am obliged, my lord. 142(3) pushes me to the Central Excise Act.
So therefore, whatever was there under the existing law can only be the mechanism, because this has to be read along with the saving clause. The Central Excise Act doesn't exist.
So my lord, the subject matter is really the interpretation of a Sanvet credit, which has to include, my lord, this amount. Because if otherwise this amount I am not being able to utilize or use it in any manner. So my Sanvet credit is not defined anywhere under the CGST Act.
No, Sanvet credit rules are there.
Sanvet credit rules is under Sanvet credit rules 2004, where it is said that a person is entitled to Sanvet credit on the input, etc. So, my lord, on the excise duty paid on input, etc. That there it is being said that it can be used as a Sanvet credit. So, under Sanvet credit, it is being mentioned the rule 3 of that. Sanvet credit under CGST Act is not defined, and under the transfer form, it is said in all input credit. The word used in transfer form is input credit under Rule 117.
The form has to be read along with the main provision.
My lord, I am correct. My lord is right. My lord is right. That is correct. But my lord, some sort of mechanism has to be provided for taking input tax, my lord.
That you advise your client, but at least it cannot be carried forward under section 140. It is not credit.
In fact, in this case, the department has also advised the petitioner that he can take the refund.
But there is no provision. He has.
So
but
then
there is
you
no provision for refund.
You approach, then there would be, if they refuse it for any. But this is something rewriting the words of the legislature, which we are not inclined. We cannot do in fact.
Have you ever applied, sir? Have you ever applied for refund?
If I apply for refund and it is rejected because rules section 11B is not applicable, it will be rejected.
Sir, and once it is specific paragraph 11 in the counter affidavit, that is the reason you have not applied.
I have
we can't help you, Mr. Counsel. You will have to go before the Central Excise authorities and seek a refund or whatever is permissible in law.
In that case, my lord will direct it, that department will process and give me the refund of that 1 crore. When they are saying that they will refund and to me 1 crore, then let them refund to me. I will apply. My lord will give me liberty to apply, and I will apply for that.
we will only say that you do not press this writ application in order to move the appropriate authority in accordance with law for seeking
That
your
is the only thing.
If my lord rather allows me to, in view of their affidavit filed, that I can file an application for refund, my lord may dispose of with giving me liberty or time to file an application for refund with the department, which department will process within certain date, my lord.
No, if you want us to pronounce upon the prayer made, we will simply say that it is not entertainable because there is no provision under the Act. Thereafter, whatever is the remedy, it is left for you to pursue.
You simpliciter withdraw that with a liberty to move before the department, and they will decide in accordance with law.
In that case,
Mr. Ashish, in your counter affidavit, have you stated that the
yes,
department has
yes,
advised him to?
yes. In paragraph 14, my lord, paragraph 14 of the counter, my lord, can you see?
Then very well. So we will.
Yes, paragraph.
Lordship, in my counter, we have said that the PLA account is concerned the same we are eligible for refund from the department. We have not said anything about his case. Specific.
Refund application also has to be made within a time frame. So
Yes, Lordship,
we will
that
not.
has to be look out.
But paragraph 14, may I read that what they have said? That in reply to the submission made in para 9 of the writ petition, it is humbly submitted, petitioner was lawfully entitled to file refund and deposit the same in cash reserve only. Then they were entitled to use the same for payment of CST, but they misuse the facility of transfer for the same against the provision of this law in this regard. So, my lord, here they are saying that I was entitled to refund. So in view of this affidavit in paragraph 14 filed by them, my lord may give some direction that my money is safe.
No direction. We will simply.
They will proceed in accordance with law.
You will. We will record for.
If he will apply for refund, we will decide the matter in accordance with the law, the existing law.
So we dispose of accordingly.
My lord may dispose it off and with the direction that I will be filing a refund application and they will dispose it off.
You listen to the order. Please give your appearances.
My lord, S.K. Mehta.
Okay. Mr. S.K. Mehta for petitioner, Mr. Ashish Kumar Ashish Shekhar for AC2, Mr. P.S. Pati.
No, Mr. Amit Kumar.
Amit Kumar. The petition has been preferred for the following reliefs. There are 1 A, B, C, D. Stop. Respondents have filed a counter affidavit and contested the claim on the legal ground that the transitional provisions of under chapter Roman 20 of the CGST Act, that is section 140, does not allow carry forward of the amount deposited in the PLA. Stop. What can be carried forward is the Senvet credit. To the electronic credit ledger. The Senvet credit line in favor of the petitioner to the electronic credit ledger. Stop. Parallel counsel for the respondent submits that a writ petitioner referring to para 14 of the counter affidavit submits that the writ petitioner would have availed of, would have filed a return.
proceeding under Jharkhand Public Land Enforcement Act being a
which would be considered in accordance with law. Stop. However, no the CGST Act doesn't contain any provision for the transitional provisions under the Act doesn't allow carry forward of the SENVAT credit to the electronic credit ledger. Stop. Land counsel for the writ petitioner, therefore, after some argument, seeks permission to pursue the matter before the competent authority by making an appropriate application for refund. Stop. Para. In view of we have taken note of the submissions of learned counsel for the parties and the stand taken by the respondents in the writ petition. Stop. Without commenting anything on the merits of the claim of the petitioner, since the petitioner is willing to pursue his application for refund before the competent authority, the writ petition is disposed of. Needless to say, if any such application is made, the same may be disposed of in accordance with law.
Deeply obliged, my lord.
My lord, we'll give an appearance slip of other assisting counsels.
Yes, you send it.
Much obliged.
Item 10, PA number 30, 2020. Ms. Amrita Sinha for the appellant, Mr. Ritesh Kumar Gupta for the respondent.
May I please, Your Lordship?
Yes.
In this matter, Your Lordship, the question of law involved is whether the learned ITAT has erred in determining on the aspiration of jurisdiction by the assessing authority under section 147 of the Income Tax Act without framing the issue in this regard. What happened in the fact of the matter is, Your Lordship, that the original assessment order was done, and thereafter the entire assessment was reopened under section 147, invoking the jurisdiction under 147. The SSC duly appeared before the assessing officer. He didn't raise any ground with respect to the jurisdiction.
Question 1 and 2, that will satisfy.
Question 1 and 2.
That will be satisfied.
Yes, Your Lordship, question 1 and 2 is sufficient enough.
That is sufficient. Because the fourth question is Supreme Court judgment, so that will see to it. That cannot.
On the basis of the judgment of the Supreme
Yes,
Court, Your Lordship. Principle of waiver.
This appeal shall be heard on the following substantial questions of law. Para 6, Roman small 1 and small 2. Stop. Call for the lower court reports in connection with.
My lord, may I indicate?
Yes.
My lord, this matter does not involve any question of law, my lord, with due respect. If your lordship may just see the order of the tribunal. And this issue is already settled, my lord, long, and it's a pure question of fact.
Are you appealing in this case?
My lord,
Mr. Garodia, you are not on the screen.
My lord, there's some problem, my lord, some network connectivity. I'm just trying to connect from other device, my lord.
May I just submit, Your Lordship, in this?
Yes.
The Honorable ITAT has held that the jurisdiction, for the very first time, the jurisdictional issue was raised before the ITAT, wherein the Honorable High Court, wherein the Honorable Tribunal, at para 7.6 of the impugned judgment, that is at page 35, has held.
My lord, I am back, my lord, if I can continue, because, or my friend wants to argue, then I can reply, my lord. It's a pure question of fact, my lord.
think Ms. Amrita was in the midst of some submission. Carry on.
Para 7.6 may kindly be seen, Your Lordship, and rightly stated by my learned senior that it's a pure question of fact. And the fact has not been gone into by the learned ITAT. That has not been. Merely on one statement in the assessment order that the records were called for, but whether the records were actually received, whether the documents on which the assessing officer and the CIT also has specifically held, that those documents were a new document and never produced before the assessing officer, and without going into these aspects, the ITAT simply has stated that as it is a question of as it is a question of law, it can be raised at any stage, and even the ground may kindly be seen, Your Lordship, this question was never raised earlier, and at the time of final argument this question was raised. Para 7.6 is very important, Your Lordship. I'm page 35. It is stated at this stage it will also be relevant to take note of the objection on behalf of the revenue that challenge to jurisdiction under section 147 of the Act has been raised for the first time before the tribunal, and that too at the particular date when it was being argued, because the grounds are stated and this ground was never raised. In this regard, we observe that as it is well settled that question of lack of jurisdiction is a pure question of law capable of being adjudicated on the basis of material on record. There is no estoppel available to the revenue on the ground that the SSC did not raise the question of jurisdiction before the lower authorities. Estoppel cannot give jurisdiction over the matter which is otherwise lacking. If an authority is found to have no jurisdiction to invoke a reopening of a completed assessment, the consent or waiver can never give the jurisdiction to the authority concerned. Such view has been expressed by so and so in the such and such judgment. In this respect, merely para 7.2 at page 33 may kindly be seen.
Whether grounds for jurisdictional ground was taken under grounds of appeal before tribunal.
The grounds of appeal are stated at para.
Para 2.
Yes, Your Lordship.
Jurisdictional ground was taken.
No, Your Lordship. I can read all the grounds which is there enumerated.
Reiterated. So unless and until a specific ground has been taken, maybe on the basis of submission.
That what my mission is, Your Lordship, that without framing the issue in this regard, the issue has been decided. Even I will show.
So one more question is required whether the order is perverse.
My lord, kindly see the ground which is taken in the tribunal order. My friend is not correct. 2 Roman 6. 2.6 is the specific ground taken before the tribunal. And the grounds specifically raised are enumerated 2 Roman 2 and 2 subclause 2 and 2 Roman 6 at 2 clause 6 is specifically taken. My lord, this is a clear case, my lord, under 147 proviso. My lord, earlier a scrutiny assessment proceeding under 143.3 was already held. It's not an assessment which was a regular assessment under 142. A scrutiny assessment was already held under 143.3 on an earlier occasion. And my lord, that scrutiny assessment order is noted by the tribunal, and it is also annexed along with the present memo. If your lordships may have a look to that scrutiny assessment order at page 21. The case was selected for scrutiny at page 21. And my lord, the only issue here is that certain expenses which the SSC had incurred, that was sought to be disallowed because there was no TDS deduction under 194C. And at the stage of scrutiny assessment itself, the assessing officer has examined those documents which is recorded in para 1 of the order itself, the assessment order. The last line, my lord, the details which were asked. Details of goods receipt with TDS reconciliation statement and proof regarding payment of tax / TDS certificate. And after recording this, the scrutiny assessment order was passed where certain amount was, small amount was only added back to my income. And that order is of the year 2011. Now, my lord, the proceedings which were sought to be initiated under 147, your lordships are aware that the period of 4 years is the limitation, if there is no concealment of facts. And if there is a concealment of fact, then the extended period of 6 years is there. Now, admittedly, in this case, the proceedings were not initiated within a period of 4 years, and it was in the extended period of limitation. Even there was no allegation, even in the tribunal order, if your lordship may see, the reason for reopening,
Let the
even
record
that,
come. Let the record come.
subject to your lordship's pleasure, my lord, I can only indicate, my lord, that this would be added to the docket of the honorable court, my lord. This no question of law involved, far less any substantial question of law.
No, let it be. Let the lower court records be called for. We will examine.
So your lordship, framing the questions of law, my lord, it's only the lower court records at this stage.
We can do either way, but we feel that in that point, the lower court records need to be summoned and the substantial question of law would be answered accordingly.
I leave it to your lordship, my lord. My duty is only, my lord, to that extent.
Right.
End of opinion.
Just a few months back also we had a similar case of scrutiny assessment order and then reopening under section 147, and actually the perversity of the order would be revealed after going through the lower court
Records. That is. One more question, sir. Whether the order is perverse in nature.
Third question, whether the order of the learned tribunal is perverse in the eye of law and of facts.
Much obliged.
Item 11.
In fact, my lord, earlier no notices were even issued at the stage of admission in tax appeal. But at least now we are getting something for admission also.
Yes.
So we need to speak something. Obliged.
Next.
Item 11.
In the next matter, your lordship, yesterday I have sent a mail with regard to the instruction received by the department in order to withdraw this tax appeal as this is below the monetary limit. I have sent the instruction on the mail.
Learned counsel for the appellant, Ms. Amrita, Income Tax Department, Ms. Amrita Sinha, submits on written, seeks permission to withdraw this appeal on written instructions furnished through mail. Since the tax effect of the disputed amount is within the monetary limits for preferring an appeal before this court in terms of the CBDT circular number 23 of 2019. Let the email be kept on record. In view of the submission and counsel for the appellant, the instant appeal is dismissed as required. Same order in item 14 also?
Yes, your lordship, same order. In that also I have circulated a mail annexing there with the instruction.
Same order in item 14.
The circular number is 3 of 2018.
3 of 2018. No, the revised circular won't apply in this case.
Revised circular, your lordship, that is written in the instruction that as per the revised circular, that is 3 of 2018.
And the other one is 23 of 2019.
23, in that the amount has not been...
Extra thing has been in.
Extra
points has been indicated.
3 of 2000.
Lordship, item 11, the limitation petition is closed.
IA number so and so is closed. In both.
Item 12. WPS number 1787 of 2020. This is Leena Mukherjee for the petitioner. Mr. Gautam Rakesh.
I pray for not to on behalf of senior advocate Mrs. M. Palmaila.
Very well, not today.
Miloj, for Union of India, Miloj.
After 2 weeks.
Miloj.
After 2 weeks, by way, last time we had given last indulgence.
Miloj, in any Miloj, it's a very short matter, Miloj.
So that we understand. So
next week, any date may fix, if possible. See legs in
last indulgence on the previous date, but Land Council for the 8th March 2022, but Ms. Leena Mukherjee, Mrs. Mahua Patel, Land Council for the petitioner seeks further adjournment on the ground of the senior counsel, Mrs. M. Park. In view of the request, the matter is simply passed over for the day. However, no further adjournment will be granted.
Item 13, WPT number 4249 of 2020, Mr. Mohammed Ahmad for the petition, Mr. Ratnesh Kumar, Mr. PS Pati for the respondent.
Counter has not been. Who was?
Yes. Counter has not been filed.
Malad, the supplementary was to be filed, Malad. You see the last.
Supplementary was to be filed.
Malad, it appears from the case status, Malad, that a fresh wakalatnama has been filed.
My please, your lordship. My please, your lordship. In this case, lordship, I have filed lordship fresh wakalatnama yesterday itself, lordship. Yesterday, lordship, I received the file. Lordship, I only pray for lordship by way of last in the lordship. The day, lordship, so that I could file supplementary affidavit, lordship.
You are not even visible, so at least focus the light on your face.
Yes, lordship.
Light is on your back. In fact, it should be on your face so that we can.
Yes, I pardon, lordship. I pardon, lordship.
Not yet.
I pardon, lordship. Yes, lordship.
The petitioner has changed his counsel after we gave last indulgence on the previous date.
That is there, lordship. That is there. Yesterday, I myself, lordship, saw the case, especially lordship. Your lordship has been pleased to give them, grant them last chance, lordship, by way of last indulgence, lordship. I saw it yesterday, lordship. So, lordship, if one more opportunity was given, lordship, I will conduct the case myself.
Mr. Sadab.
Shahabuddin, lordship.
Sahabuddin.
Mohammed Shahabuddin.
Mohammed Sahabuddin. When counsel appears today and submits that the petitioner has executed wakalatnama in his favor after taking no objection from the previous counsel. Wakalatnama, yesterday you have filed wakalatnama?
Yes, lordship, in second half yesterday, lordship.
Stop. We seek short adjournment. Earlier the matter was adjourned on repeated dates and by way of last indulgence on 23rd March 2022. Stop. However, in view of the request made by the present counsel for petitioner, the matter is adjourned to, we'll keep it on Tuesday.
Lordship, today, lordship.
Whatever you have to file, you file, otherwise we will decide.
My lords, there is probably one more defect, my lords, in this petition, my lords, because the main issue, my lords, is because that they could not file their ITC 01 on time because of defects in the portal.
No, that we understand. So let the council go through his brief.
Yes,
that is the purpose for adjourning it only.
Yes,
we'll keep it on Tuesday.
Yes,
Yes, lordship.
Yes, sir.
12th April. No more adjournment shall be given.
Obliged.
Obliged.
The name of Mr. Swell shall be reflected in the cause list for the petitioner.
Item 15, first appeal number 35 of 2021, Mr. Mohammed Zaid Imam for the appellant.
I think notice will go.
Issue notice on the respondent under registered cover with AD and speed post and ordinary process, for which requisites be filed within 2 weeks. Peremptory. Both in a limitation matter and on the main memo of appeal.
Item 16, first appeal number 46 of 2021, Mr. Mukesh Kumar for the appellant, Mr. Rajiv Ranjan Kumar for the respondent.
May I please, my lord?
Yes, I am appearing on behalf of the respondent, my lord.
Right. So, divorce granted or refused?
Refused, my lord.
Dismissed, suit dismissed.
Yes, dismissed.
Yes,
So go for mediation.
yes, my lords.
Yes, sir.
So we'll fix a date for your appearance. लिखिए. Respondent has entered appearance on notice through learned counsel, Mr.
Sumit Prakash, my lord.
Sumit Prakash. Stop. Learned counsel for both the parties agree that effort for amicable settlement of the matrimonial dispute between the parties may be explored through mediation at this appellate stage also at Jhalsa. Stop. Both the parties are willing to attend mediation physically
Yes, my lord.
Yes, my lords.
at Jhalsa. Stop. In that view of the matter, order का text वही रहेगा. Appearance on 16th April.
Yes, my lords.
16th April, yes.
16th April at 10:30 a.m.
Yes.
The member secretary can also be opposed from the following member. Parties will cooperate. Appellant shall pay a sum of rupees 1,500. She has to come from Patna.
Patna, yes.
My lord, I am already paying rupees 10,000 as interim maintenance, even though I will pay.
No, for attending mediation,
Yes, my lord.
1,500. On each date she attends before in presence of so and so. Now, if agreed terms and conditions are arrived at, it may be signed under a joint signature and be submitted along with the report 4 weeks thereafter. Matter will be listed in the week of 6th June 2022.
Yes.
Along with
Item 70, WPT number 319 of 2021, Mr. Ranjit Kushwaha for the petitioner, Mr. Sukumar Yadav, Mr. P.S. Pati for the respondent.
Yes, my lords, I am Hardik Vora appearing on behalf of Mr. Kushwaha.
Yes.
I am led by Mr. Hardik Vora.
Yes, my lords. We have filed affidavit placing there on the appellate order.
Yes.
Yes.
Now the matter may please be disposed of and the interim relief staying the garnishee orders, 2 garnishee orders may become absolute, my lords.
It has been decided in your favor.
It has been decided in my favor. There are 2 appellate orders.
Manoj, the interim order may not be made to be absolute. It can be disposed of as becoming infructuous, Manoj. Because one, Manoj, they have only. I Manoj. Yes, Manoj. Because if they challenge the demand notice as well, they've only challenged the recovery notice under DRC 13. They've not challenged the demand notice. Had there been a stay of the demand notice and the appeal had been dismissed, then, my lords, the interim order could have been made absolute. Or, my lords, if this writ was admitted, then, my lords, the interim order could have been made absolute. But because the basis of the recovery notice is the demand, and that demand itself has gone, my lords, this has become infructuous. There's no question of the interim order being made absolute.
So why don't you withdraw that?
My lords, I'll have to take it.
After the demand itself is non-existent, then where is the question of keeping the demand?
No question of demand garnishing.
Or recovery, keeping it alive? We can record your statement that the authority would take a decision on recall of the garnishee order within
Yes, my lord.
2 weeks' time.
Yes.
In fact, if I may be permitted to submit something on this, my lords.
Yes.
Section 107 of GST Act itself states the proceedings once 10% of the demand has been paid by the person.
Right.
Now, after that, once the appellate order is decided in my favor, then that stay would again become absolute. So there is no question of any garnishee proceeding. So it has to go, my lords. I believe
So no formal order is required then?
No formal order.
For
is
the
required.
stay, no formal order, my lords, because by provisions of section 107, then stay would be granted once there is a appeal filed by the person.
Here appeal has been allowed.
Here appeal, the last step has been done and appeal has itself been allowed.
There is
So there is
nothing
no question of
giving any reasoning to the order. Practically, it has become infructuous.
Yes, yes.
it has become infectious along with even garnishee order becomes infectious.
Yes,
So my
yes.
lords, yes.
Yes,
So my
Malad,
lords
it
may
has become
observe that.
We will only say that, in fact, the appellate authority himself says that Prapat DRC 07 Vidhi Sambat एवं न्याय संगत नहीं है.
नहीं है.
Yes, Malad, that is the demand order, Malad.
Third learned counsel for the petitioner, Mr. Hadik Vora, assisted by Mr. Ranjit Kushwaha and Mr. Salona Mittal, AC2 GA1 staff. The writ petition was preferred with the following reliefs. Paragraph 1 and 2. Thereafter, interlocutory application was preferred. Interlocutory application bearing number 601 of 2021 was preferred, seeking amendment due to subsequent developments. Petitioner sought addition of further prayer under para 1 as sub para 3 under para 1 to the following effect. ये पेज 80 पे है, आइए में continuous पेज. One more IA was filed.
Yes.
But this was the only IA.
No, this was the only IA, my lord. No further IA was filed.
The matter was heard earlier on March 2021. The order dated 25th March 2021 is extracted here in below. By the order dated 25th March 2021, the operation, implementation, execution of the impugned garnishee notice dated 14 December 2020, issued in form GST DRC 13 to the petitioner's banker, namely Andhra Bank, branch Jagatpura, Jaipur, Rajasthan, as well as the impugned garnishee notice dated 15 January 2021, issued in form GST DRC-13 to third party, namely Messrs. Adani Power within bracket Jharkhand Limited within bracket SEZ Unit bracket close, as contained in Annexure 15 of the interlocutory application, being IA number 601 of 2021, was stayed till the next date. Thereafter, when the matter was taken up on 23rd March 2022, then counsel for the petitioner, Mr. Hadik Vora, submitted that both the appeals have been decided in favor of the petitioner under Section 107 of the JGST Act 2017. Stop. for adjournment, the appellate orders, both of them have been filed.
Yes, my lords.
Both the appellate orders have been brought on record by way of a supplementary affidavit dated 1st April 2022 with copy to the Respondents' Council. Stop. The two appeals bearing appeal case number GA-GST-03/20-21 and appeal case number GA-GST-02/2020-21 pertaining to the period 2018-19 and 2019-20 have been decided in favor of the petitioner. Stop. Who has enclosed the copy of the appellate orders with consequential form GST APL 04 passed by the learned Joint Commissioner within bracket Appeal, Santhal Paragana Division Dumka to the supplementary affidavit as Annexure 17 series. The relevant part of the order is quoted here under. ये फर्स्ट वाला है पेज 6 पे, इसका ये क्वेश्चन कोट करिएगा, पेंसिल से मार्क कर दे रहे हैं। और दूसरा वाला है पेज 9-10 पे, इसका ये पोर्शन कोट करिएगा। दोनों appellate orders का डेट 1st July 2021 and 19th April 2021. Stop. Learned counsel for the petitioner submits that the writ petition may be disposed of since no demand notice survives. Disposed of since no demand notice survives. Demand notice under GST DRC 07 survives in view of the appellate order passed in his favor. In favor of the petitioner. Stop. Then counsel for the respondent state, Mr. Salona Mittal, submits that the writ petition has become infructuous on account of the in view of the passing of the appellate order annulling the demand notice under GST DRC 07. Stop. Therefore, the question of recovery pursuant to the garnishing notice under GST DRC 13 does not arise. DRC 13 dated 14 December 2020 and 15 January 2021 bill does not arise. Stop. We have taken note of the subsequent developments. The developments that have taken during pendency of this application. Stop. Petitioner has succeeded before the appellate authority and the demand notice itself stands set aside. As such, the writ petition becomes infructuous. Stop. It is disposed of accordingly.
And that's only one request. Some clarification may specifically been made for the reason that respondents counsel is saying that they will finalize on these things. My lords, I am only requesting, my lords may finalize it here that the garnishee order would also become infructuous considering the fact that demand notice is infructuous.
Mr. Mittal, you do not dispute that there is anything left in the garnishee?
No, my lords, I do not dispute. Nothing is left, my lord. The basis of the demand notice has gone, my lords.
Yes, वही तो लिखा है, the garnishee notice also therefore do not survive.
Yes.
Deeply obliged, my lords.
Item 18,
Obliged.
WPT number 1823 of 2021, along with item number 19 and 20. Mr. Nitin Kumar Prasadi for the petitioner, Mr. Sachin Kumar for the respondent.
Lordship,
Sir,
may I,
yesterday a letter has been circulated by the office of Mr. Pati.
yes, Your Lordship, we had requested for an adjournment and all these three because we have sent the counters for vetting. So we'll be filing it within 2 or 3 days. So the moment it comes back. So I was only requesting let this matter be taken up on Thursday next physically because my request is made to take this matter in physical court. Your Lordship.
Next Thursday is probably closed now.
Mr. Mittal is right. 14, 15, there is a holiday minutes.
Yes, Your Lordship.
And if at all they file any counter affidavit minutes, then in that event we also need to have the instructions and file rejoinder if at all required.
Right.
Because GSTN was notified as a opponent only because of the fact that we were unable to file appeals. So to that extent only they were to assist the court. So we are not aware what grounds they are taking or what is the outcome of their instructions.
So 21st April 2022.
Minutes only one request. Minutes 21st to 23rd. I am out of town for a marriage in the family. Minutes.
Lordship, let it be on 18th or 19th, any physical day.
Yes. 18th or 19th.
Thursday is a holiday, so I don't think my senior will.
19th.
Yes, sir.
Then counsel for the GSTN, Mrs. Randana Mukherjee, AC to Mr. P.S. Pati seeks short time to file counter affidavit in terms of the orders dated 23rd February 2022 and 14th March 2022. Stop. Time as prayed for is allowed by way of last indulgence. As prayed for by learned counsel for the parties, post the case on 19th April 2022. Stop. Rejoinder be filed within this time.
Can I only take one liberty? We had already furnished the written submissions along with the judgments. Now, thereafter, after furnishing of the last paper book, a lot of new judgments have come from different courts across the nation. Can we file a second paper book?
Just wait. In that case,
We will file revise.
then let it be on 26th April.
Yes, I'll do that.
26th.
I will do that.
Yes.
Petitioner is allowed liberty to file revised written notes and compilation additional documents.
Obliged.
Yes.
Item 21, WPT number 1929 of 2021, Mr. Sumit Goria for the petitioner, Mr. Rahul Lamba, Mr. Amrita Sinha for the respondent.
Your Lordship, in this case, I have requested for an adjournment.
Yes. This was that direct tax.
Yes, Your Lordship, Direct Tax Vivad Se Vishwas Scheme Act wherein it has been 9C is under there.
Yes.
I have prayed for an adjournment, Your Lordship. In this case, as certain instruction I sought from the department, which I have not yet received, Your Lordship. For the reason the time barring assessment was there and the department is entirely busy, Your Lordship. So they have requested that at least 2 to 3 weeks time may be given so that, and we are also in process of contacting our legal cell, Your Lordship, in Delhi so that the assistance can be also be given. So I am praying in this regard.
26th of April.
26th.
My lord, it may be, I have objection, my lord, because on earlier occasion also they have taken time, my lord, by daughter
No,
dated
we have not taken your time, Your Lordship, but we have argued out the matter on the last occasion.
Yes,
The matter was argued at length.
Yes, Your Lordship, it was argued at length and then it was
to seek further instructions, my lord, the matter was urgent on 9th March 2022, my lord. My only prayer would be, my lord, that it may be fixed on 28th of April, my lord.
We were already fixing it on 26th.
26th.
You want 28th?
No, 28th, my lord, 20 Tarikh.
20
It won't be such.
Virtual day.
May I pray
Yes,
your
my
let it be on 27th, Your Lordship, because I don't think so. Then again, if I short for an adjournment, it will again be creating a difficulty for this court, Your Lordship.
Very well,
So on the
27,
safer side, let it be
27 by way of last chance.
27th April.
Earlier occasion, I have never short for time in this matter, Your Lordship.
So we understand we had put to you certain pertinent queries and then you,
For that purpose only, Your Lordship, and I have made a requested for the information which I have not received.
Ms. Amrita Sinha, on the request of learned counsel,
The judgment also, latest judgment in this.
Ji, Your Lordship, for that purpose
department
only we
heard
have.
the case on 27th April 2020. By
Much
way of last indulgence.
Much obliged.
Item 22, WPT number 3133 of 2021. Ms. Sima Kumari, Mr. Manoj Kumar Chaube for the petitioner, Mr. P.S. Pati for the rest.
My Lordship, learned counsel Mr. P.K. Sahu will assist me in this case.
Counter has not been filed.
My lords, I was directed on the last occasion to file counter affidavit. I just pray 1 week time to file counter affidavit. In fact, I will file it by tomorrow.
Has the petitioner brought those notifications on record?
Yes, it has filed the supplementary. They have filed it. Yes,
Affidavit has been filed.
Okay. So counter of only DDGI.
But for that, my lords, I pray only for a week's time to file.
And counsel for the respondent DDGI, Mr. Ratnesh Kumar prays for short indulgence as counter affidavit is ready and will be filed by tomorrow.
Yes.
Stop. As such matter is passed over for the day. Petitioner, who is for petition?
Yes, my Lordship.
If you would be able to file rejoinder within this time by next Wednesday,
Okay, my Lordship.
very well. Rejoinder, if any, be also filed within this time.
Item 23, WPT number 5139 of 2021. Along with item number 24, Mr. Nitin Kumar Prasadi for the petitioner, Mr. Sukumar Yadav for the response.
Made case, my lords. I am assisting Mr. Pasari. I will be making submissions, my lords. My lords, in this matter, your lordships will recall, this is an issue relating to refund, where for the same period for the Dhanbad circle, your lordships were pleased to allow our writ petition by a detailed order, which was dated 9th of February 2021, where your lordships had held that in the absence of any registration or an assessment, the respondents could not have withheld the amounts which were sought in refund, and your lordships had directed that those amounts may be refunded after verification. Now, my lords, even in these two writ petitions, the same period is involved, which is 2014-15 and 2015-16. Now, I'll invite your lordship's attention to a compilation that I have filed, my lords, with some judgments. And my lords, I will also be relying on a synopsis that I have filed. It's a short synopsis filed separately in both the matters. Do your lordships have the compilation, my lords?
Yes, yes.
Now, my lords, in these...
We are just trying to find out as to, Mr. Mittal, you took time to file counter affidavit to just bring on record the state stand.
My lords.
Now, is there a real contest on what we have decided in the earlier writ petition of the same petitioner concerning Dhanbad division, or it's only a repetition of the argument or addition of grounds which you are not reflected in your original order?
I have gone through my lord's original order, my lords, and there is one thing that is staring at my face, that is, my lords, the limitation. My lords, and my lords, there is only one justification in the counter affidavit, my lords. It is my duty to place it, my lords. It's para 11, that the tax has been paid as admitted tax, my lords. And my lords, under the VAT regime, my lords, there is a provision for self-assessment. If they've paid it as admitted tax, then the question of limitation does not arise. As I admit that
Will it be a tax or a simple deposit upon a compulsion?
Lords, again, my lords, my contention is that there is no evidence
of it is that we have to write judgments on the same point and the state is the same party, only the difference of division.
My lords, I understand that, my lords, but this counter affidavit has been brought on record, my lords, and we have to place, my lords, at least the two
both of you prepare a common judgment and give it to us on agreeable points. We will deliver it. It's an onerous task to pronounce on the same issue again.
Same issue every time, same judgment.
In other
Here, same party also.
We have heard that in other jurisdictions, both the parties propose a.
Yes, my lords, in Bombay High Court, it was called minutes of orders, my lord. And
yes,
to tender
It's even the Madras High Court has started following the same lines, my lords. Madras High Court is also, let's say, inviting orders from the advocates on record, and there are common issues which is taken and the orders are pronounced.
There are some cases in Supreme Court also where we, my lords, just give a suggested order where there are repeated issues which are involved, but that is a matter of practice, my lords.
That's an informal practice.
My lords, I've gone through the rejoinder also, my lords, and my only contention was, my lords, even if we give the minutes of orders, my stand may be recorded and their rejoinder may be recorded.
And your stand has been recorded in the previous order also.
My lords, the admitted tax portion was not there, my lords, in the previous order.
So now the limitation period has crossed, so how can we help that?
Well, my point was that since it is admitted, since you have yourself admitted that you're paying it, then the limitation would not arise.
May I say this, my lords, on that point with respect to admitted tax? The question, my lords, is that in any tax, there has to be an appropriation. Irrespective of what the amount is, the appropriation has to be by method known to law. And in my compilation, I've referred to just one judgment I'll refer to on this aspect of admitted tax. That what the Punjab and Haryana High Court was also seized with a similar situation, page 153, my lords. And that judgment has been followed in subsequent decisions also. I'll just refer to one para. My lords, para 13.
In either case, there has to be an assessment, whether by the assessing officer or by the SSC.
Absolutely.
Here the SSC
without any authority being exercised, my lords. That's the observation of the Honorable Punjab and Haryana High Court also in para 13, where they say that as far as the amount deposited by the petitioner is concerned, case of the petitioner is that the same was deposited under coercion. Case of the respondent was that the same was deposited voluntarily. Whatever be the position, unless there is an assessment and demand, the amount deposited by the petitioner cannot be appropriated. No justification has been shown for retaining the amount deposited except saying that since it was a voluntary deposit, in view of this admitted position, petitioners are entitled to return the amount paid. Squarely covered. And this has been followed, my lords. Will note in the index in serial number 13 and 14, again Punjab and Haryana High Court, but squarely saying that unless there is an appropriation, any amount cannot be accounted for, my lords.
That you have incorporated in your submissions.
My lords, in my synopsis, my lords, it's squarely put. My lords will kindly have para 9, my lords, of synopsis.
So we will keep it on Tuesday for orders. Tuesday is Tuesday we'll keep it for orders. Yeah, I've rejoined after a long gap. I'll go through the file. We will go, both of us.
My lords, will it be a physical hearing, my lords?
Tuesday, of course, is a physical day. In this week, I propose to continue as virtual court because I have come back from an operation. Next week, I will take a call.
My lords.
Tuesday, we will keep it under orders. Either we'll dictate it or we'll bring the draft and pronounce it.
My lords, we'll bring the draft, my lords.
Very well, very well.
Bring the draft.
No, I think the court proposed that the court will be bringing the draft, not the lawyers, my lords.
My lords, like a minutes, my lord, which will be helpful for the court, my lords.
Very nice of you. It will help us.
Yes, my lord.
We'll also attempt to do that, my lords, but our submissions otherwise are already in the synopsis.
No, we understand the gist of what would follow is there in our previous order.
Yes.
My lord.
The rest of the narrative, if in a short form, should be taken in the present order so that the relevant facts, because every case has its own facts, so tax case can be similar. The issues may, of course, be similar and may govern both all the cases. So for that, one narrative is required shortly.
Yes.
Post the case on 12th April 2022 for others. That's it.
Great.
So that's all for the day, brother.
Yes.
So, thank you. Thank you.
तिवारी सर जरा आइटम नंबर 25 में बताइए ना, टाइम लिए हैं क्या पिटिशनर?